Magna Carta Libertatum is a charter of rights agreed to by King John of England at Runnymede, near Windsor, on 15 June 1215. First drafted by the Archbishop of Canterbury to make peace between the unpopular king and a group of rebel barons, it promised the protection of church rights, protection for the barons from illegal imprisonment, access to swift justice, and limitations on feudal payments to the crown, to be implemented through a council of 25 barons. Neither side stood behind their commitments, and the charter was cancelled by Pope Innocent III, leading to the First Barons' War. After King John's death, the regency government of his young son, Henry III, reissued the document in 1216, stripped of some of its more radical content, in an unsuccessful bid to build political support for their cause. At the end of the war in 1217, it formed part of the peace treaty agreed at Lambeth, where the document acquired the name Magna Carta, to distinguish it from the smaller Charter of the Forest which was issued at the same time. Short of funds, Henry reissued the charter again in 1225 in exchange for a grant of new taxes. His son, Edward I, repeated the exercise in 1297, this time confirming it as part of England's statute law. The charter became part of English political life and was typically renewed by each monarch in turn, although as time went by and the fledgling Parliament of England passed new laws, it lost some of its practical significance. At the end of the 16th century there was an upsurge in interest in Magna Carta. Lawyers and historians at the time believed that there was an ancient English constitution, going back to the days of the Anglo-Saxons, that protected individual English freedoms. They argued that the Norman invasion of 1066 had overthrown these rights, and that Magna Carta had been a popular attempt to restore them, making the Charter an essential foundation for the contemporary powers of Parliament and legal principles such as habeas corpus. Although this historical account was badly flawed, jurists such as Sir Edward Coke used Magna Carta extensively in the early 17th century, arguing against the divine right of kings propounded by the Stuart monarchs. Both James I and his son Charles I attempted to suppress the discussion of Magna Carta, until the issue was curtailed by the English Civil War of the 1640s and the execution of Charles. The political myth of Magna Carta and its protection of ancient personal liberties persisted after the Glorious Revolution of 1688 until well into the 19th century. It influenced the early American colonists in the 13 colonies and the formation of the American Constitution in 1787, which became the supreme law of the land in the new Republic of the United States. Research by Victorian historians showed that the original 1215 charter had concerned the medieval relationship between the monarch and the barons, rather than the rights of ordinary people, but the charter remained a powerful, iconic document, even after almost all of its content was repealed from the statute books in the 19th and 20th centuries. Magna Carta still forms an important symbol of liberty today, often cited by politicians and campaigners, and is held in great respect by the British and American legal communities, Lord Denning describing it as the greatest constitutional document of all times, the foundation of the freedom of the individual against the arbitrary authority of the despot. In the 21st century, 4 exemplifications of the original 1215 charter remain in existence, 2 at the British Library, 1 at Lincoln Castle and 1 at Salisbury Cathedral. There are also a handful of the subsequent charters in public and private ownership, including copies of the 1297 charter in both the United States and Australia. The original charters were written on parchment sheets using quill pens, in heavily abbreviated medieval Latin, which was the convention for legal documents at that time. Each was sealed with the royal Great Seal made of beeswax and resin sealing wax. Although scholars refer to the 63 numbered clauses of Magna Carta, this is a modern system of numbering, introduced by Sir William Blackstone in 1759. The original charter formed a single, long unbroken text. The 4 original 1215 charters were displayed together at the British Library for one day, 3 February 2015, to mark the 800th anniversary of Magna Carta. The Great Charter was referred to in legal cases throughout the medieval period. For example, in 1226, the Knights of Lincolnshire argued that their local sheriff was changing customary practice regarding the local courts, contrary to their liberty which they ought to have by the Charter of the Lord King. In practice, cases were not brought against the king for breach of Magna Carta and the Forest Charter, but it was possible to bring a case against the king's officers, such as his sheriffs, using the argument that the king's officers were acting contrary to liberties granted by the king in the charters. In addition, medieval cases referred to the clauses in Magna Carta which dealt with specific issues such as wardship and dower, debt collection, and keeping rivers free for navigation. Even in the 13th century, some clauses of Magna Carta rarely appeared in legal cases, either because the issues concerned were no longer relevant, or because Magna Carta had been superseded by more relevant legislation. By 1350, half the clauses of Magna Carta were no longer actively used. Between the 13th and 15th centuries, Magna Carta was reconfirmed 32 times according to Sir Edward Coke, and possibly as many as 45 times. Often the first item of parliamentary business was a public reading and reaffirmation of the Charter, and, as in the previous century, parliaments often exacted confirmation of it from the monarch. The Charter was confirmed in 1423 by King Henry VI. During the 16th century, the interpretation of Magna Carta and the First Barons' War shifted. Henry VII took power at the end of the turbulent Wars of the Roses, followed by Henry VIII, and extensive propaganda under both rulers promoted the legitimacy of the regime, the illegitimacy of any sort of rebellion against royal power, and the priority of supporting the crown in its arguments with the papacy. In the early 17th century, Magna Carta became increasingly important as a political document in arguments over the authority of the English monarchy. James I and Charles I both propounded greater authority for the crown, justified by the doctrine of the divine right of kings, and Magna Carta was cited extensively by their opponents to challenge the monarchy. The first attempt at a proper historiography was undertaken by Robert Brady, who refuted the supposed antiquity of Parliament and belief in the immutable continuity of the law. Brady realized that the liberties of the Charter were limited and argued that the liberties were the grant of the king. By putting Magna Carta in historical context, he cast doubt on its contemporary political relevance. His historical understanding did not survive the Glorious Revolution, which, according to the historian J.G.A. Pocock, marked a setback for the course of English historiography. In the late 18th century, the United States Constitution became the supreme law of the land, recalling the manner in which Magna Carta had come to be regarded as fundamental law. The Constitution's Fifth Amendment guarantees that no person shall be deprived of life, liberty, or property, without due process of law, a phrase that was derived from Magna Carta. Initially, the Whig interpretation of Magna Carta and its role in constitutional history remained dominant during the 19th century. The historian William Stubbs's Constitutional History of England, published in the 1870s, formed the high water mark of this view. Stubbs argued that Magna Carta had been a major step in the shaping of the English nation, and he believed that the barons at Runnymede in 1215 were not just representing the nobility, but the people of England as a whole, standing up to a tyrannical ruler in the form of King John. In many literary representations of the medieval past, however, Magna Carta remained a foundation of English national identity. Some authors used the medieval roots of the document as an argument to preserve the social status quo, while others pointed to Magna Carta to challenge perceived economic injustices. The baronial order of Magna Charta was formed in 1898 to promote the ancient principles and values felt to be displayed in Magna Carta. Magna Carta continues to have a powerful iconic status in British society, being cited by politicians and lawyers in support of constitutional positions. Its perceived guarantee of trial by jury and other civil liberties, for example, led to Tony Benn's reference to the debate in 2008 over whether to increase the maximum time terrorism suspects could be held without charge from 28 to 42 days as the day Magna Carta was repealed. Although rarely invoked in court in the modern era, in 2012 the Occupy London protesters attempted to use Magna Carta in resisting their eviction from St Paul's Churchyard by the City of London. In his judgment, the Master of the Rolls gave this short shrift, noting somewhat dryly that although Clause 29 was considered by many the foundation of the rule of law in England, he did not consider it directly relevant to the case, and that the two other surviving clauses ironically concerned the rights of the Church and the City of London and could not help the defendants.